Good morning, Mr. Liss.
Good morning, Your Honor. My name is Stuart Liss. I'm the plaintiff appellant in this matter. This case was commenced in Middlesex Superior Court. Very early in the course of the litigation, Mr. Studeny filed a motion for summary judgment, which was allowed on the ground that there was no recovery in the underlying litigation of Studeny versus Walmart stores, and Justice Chernoff thereupon dismissed the case. I appealed to the appeals court, and this court transferred the case here on its own initiative. The factual background in this case can be divided into two categories.
I actually think we may know the facts.
All right, then if that's the case, I will move on to...
How much is your, out of curiosity, how much would your quantum Merowith charges be? Have you calculated them?
Using my time in billing records, and I realize that's only one element that's appropriate in determining quantum Merowith, that would come to approximately $39,000 at the rate of $150 per hour as specified on the documentation submitted.
Now the question here is, we've already held, have we not, that if a client terminates a contingent fee agreement, the lawyer may, absent bad faith, I'm part of the lawyer, recover in quantum Merowith. Isn't that
the court has ruled that in cases where there is a recovery in the underlying case, which obviously did not occur in the instant case.
Well, there's two things different about this case. One is what you just mentioned. The second thing is that the client did not really terminate the agreement in the usual sense. He refused to cooperate on an essential point, which was money for an expert. Am I right?
Two essential points, Your Honor. You've just mentioned one.
There's another one, I know. What's the other one?
The other essential point was that although Mr. Studeny argues I disobeyed his request to settle the case, he, in fact, when I submitted a draft settlement demand to him and requested his review of it and requested additional information to complete it, he did not do so.
So this is really not an outright termination case. It's, from your point of view, it's a breach of the contract.
That is correct.
But you say the breach occurred when you wrote your letter of April 4th. Is that correct?
No, I'm saying the breach occurred first in the summer of 1999.
Is there something in the contingent fee agreement that says I have to respond to the to everything that you write? I mean, why is that a breach that he doesn't respond?
The contingent fee agreement requires the client to cooperate with the attorney. Now, certainly I could hypothesize a situation where an attorney's request might be so minimal in relationship to the case that the failure of the client to cooperate would not be a breach. But please keep in mind that in this case, the cooperation that was denied was the review of a draft demand letter, the provision of additional facts so it could be served upon Walmart.
Are you arguing, I know there's no recovery here, but are you arguing that these alleged breaches, in your view, constitute bad faith?
Yes, I am, Your Honor, that these breaches rise to the level of bad faith on the part of the client and therefore would support a narrow exception to this court's following the California rule.
Where's the bad faith?
The bad faith is first, let's address first the failure to provide additional funds.
Well, what I see is a letter saying April 4th, dated April 4th, saying I'm going to need these funds by June 30th, and on April 6th you move to withdraw.
That is correct, because Mr. Studeny made it clear that he was not going to furnish the funds.
Well, he has a right not to do that, doesn't he?
He has a right not to do that, but let's look at the context in which Mr. Studeny allegedly made that assertion. Mr. Studeny has maintained in his opposition to my case that he continually told me he was unable to afford to finance the expenses necessary to properly present the case at trial. The bad faith element comes in as to whether or not Mr. Studeny's assertions are true. Now, because there's been no trial in this case and there's been minimal discovery, this court does not have sufficient information to determine whether or not Mr. Studeny's assertion of financial poverty is true or not.
Mr. Liss,
yes.
Mr. Studeny, at any point in time particularly if there's been no recovery, could say, you know what, I just don't want to pursue this anymore. Couldn't he?
Yes, he could, but he didn't. That's the
Well,
distinction in this case.
He ultimately did. I mean, he did by, I guess, telling you he wasn't going to pay any more of the fees, although, you know, did you have a conversation between April 4th and 6th?
See, my difficulty with Your Honor's statement of the facts is that if this case had gone to trial, that would be a permissible inference to draw from a jury verdict for Mr. Studeny. But where this case is before the court on a motion for summary judgment.
But I just don't see any evidence from which you could possibly make out a claim of bad faith here.
I believe there's sufficient evidence in the record to show that Mr. Studeny could, in fact, afford to finance the litigation within the scope that I had requested and within the scope of my explanation for the need of that money, and that by misleading the court, the lower court, when he claimed he could not afford to finance the litigation, as he had misled me, that's the act of bad faith.
There are essentially two rules out there, and maybe I'm wrong, but one is California that says no matter what, unless the contingency occurs, the client wins the case.
That is correct. That's the
You're out.
California rule.
And the other is New York and some other states, which apparently say, no, we'll take a look at it at the time of the breach, alleged breach, and if, you know, there is fault on the client, the lawyer will be able to recover. That's about it, isn't it?
Those are the two primary approaches which are taken in these situations. And my request to this court, contrary to what the amicus suggests in its brief, is not that this court repudiate the California rule. I fully understand that the California rule is an appropriate rule for a client who wishes to, as Justice Botsford said, terminate the litigation, or for a client who wishes to discharge the attorney. What I'm asking is for this court to look at a very narrow exception, and that is where a client acts in bad faith in his relationship with the attorney. Now, the amicus...
But that's going to arise in every single case, isn't it? If an attorney is discharged and he or she's going to say, well, the client's acting in bad faith. So isn't the California rule just simpler, cleaner, particularly in requiring a recovery in the underlying case?
Well, it's certainly simpler and cleaner in that sense, but what I would suggest to this court that issues of good faith and bad faith, which are basically questions of fact, are issues that are very familiar to the courts of the Commonwealth. It was, for example, the issue that was used to distinguish whether or not an employee had a right to recover in the Fortune versus National Cash Register case and the progeny that flowed from that case. It's an issue that's used in Uniform Commercial Code cases. It's an issue of fact that's used in 93A cases. So,
but Mr. Liss, I mean, it would be different if there was a recovery here. I mean, that's really where it triggers this bad faith question, whether the discharge is because the person doesn't, as in Fortune, doesn't want to give some of that recovery to his attorney, but you have no recovery here.
that is correct, and Your Honor is correct in pointing out that it would be different if there had been a recovery in the Walmart litigation.
The case had some merit, at least. A motion for summary judgment by Walmart was defeated, right?
That is correct.
And
using my work product, Mr.
Using your work product, and then, of course, the jury found the other way at the end, but...
The amicus suggests that it would be bad public policy if this court were to carve out the narrow exception that I'm requesting. And I would like to suggest that the issues of public policy can be addressed, as I have suggested in my brief, by the use of the good faith, bad faith distinction. I'm not asking this court to overturn the rule of law that says a client may discharge the attorney at any time. And I'm not asking the court to overturn the rule of law that says a client may terminate the litigation.
Isn't one of the underlying premises to the theory, the whole concept of quantum merit, that the person being sued received something of value?
That is correct.
It seems to me that the focus of your lawsuit is that you are putting the value on the reasonable value of your services, not that the defendant in this case received something of value, because what they were looking for in this case, what everybody was looking for, was the contingency of a favorable outcome.
What I'm suggesting, Your Honor, is that the definition of value that's used in the discharge context, which is to say a recovery in the underlying litigation, should be a little broader in the context of a client acting in bad faith.
But
and
why?
That
Why? Because the bottom line is the same. You never expected to get anything if there weren't a recovery in the underlying case. There was no recovery in the underlying case, so you haven't gotten anything. So
What
why
I did
should it be any different?
What I did expect to get was an opportunity to use my best efforts to win that case.
Maybe you're better off because maybe you would have spent an awful lot of time between the summary judgment, between the discovery and the end of the trial, and you would have lost anyway, and you would have expended many, many, many hours more.
Well, that's possibly true, but what happened in...
According to you, that was what was going to happen.
Yeah, you wrote a letter saying, I'm very pessimistic about the results in this case.
So you didn't really expect to get a recovery here, so why should, just because the client didn't want to pursue it with you, mean that you should get a recovery?
See, where I differ with Your Honor is the assumption of fact Your Honor has just made, that the client didn't want to pursue it. In my view, that's a disputed fact, and that has not been resolved at trial, and there has been no meaningful discovery which addresses that fact. And in the context of a summary judgment appeal, I would respectfully suggest it's improper for the court to assume that fact.
No, but the fact I said was that the client didn't want to pursue it with you, and he obviously didn't because he ended the agreement with you. So he didn't want to pursue it with you, and...
Well, the client did not end the agreement with me, Your Honor. The Franklin Superior Court, on motion and after hearing at which Mr. Studeny appeared, permitted me to withdraw under the rules of the court. So this is not a situation where the client ended the representation to pursue it with someone else.
Mr. Liss, this is on a different subject, but what was the justification for your writing in July of '98 saying that if Mr. Studeny were to reject the compromise you were offering, that you might have to seek compensation? What would give you under that contingent fee agreement? What would be your right to seek compensation?
At that point in time, Your Honor, it was clear that Mr. Studeny, and I believe my letter reflects this, was about to breach the contingent fee agreement.
And breaching it is when he decides he doesn't want to keep paying for the expenses?
Breaching is when, at that point, the breach occurred with respect to his refusal to continue to, pay reasonable disbursements in connection with the litigation.
Mr. Liss, let me ask, it's the Chief
Yes, ma'am.
speaking. Let me ask the question this way. Mr. Studeny represented himself at trial, correct?
That is correct.
So it's not as if he walked away from the case. He proceeded with the case.
That is
and
correct.
he represented himself. And after special questions, he recovered nothing, correct?
That is correct.
Meanwhile, you had an attorney's lien, and had he prevailed at trial, you would have been entitled to some recovery, correct?
That is correct.
I can imagine that there are circumstances which are different from this one, where an attorney files a contingency fee agreement, expends time and money, and the client then decides, maybe the client has changed financial circumstances, that the client doesn't want to advance further fees for experts or otherwise, doesn't want to represent himself, and doesn't have the money to pay for another attorney, and so simply walks away from the case, the attorney having done everything that the attorney was required to do. It would seem to me that that might suggest that there should be some recovery, notwithstanding the terms of the agreement, because nothing has happened. But here we have a really classic case. Client, constructively or not, terminates attorney 1. Client proceeds with attorney 2, only in this case it's self-represented, goes all the way to trial, doesn't recover, contingency agreement kicks in, no recovery. Do you see the difference between those two?
Well, Your Honor's hypothetical actually argues a situation broader than the one I'm arguing to this court, because in my view, in the position I'm advocating, if a client, let's say, loses his or her job, or there's an illness in the family, and the financial circumstances change, that would be good faith, not bad faith. But if the client, on the other hand, could afford to fund the litigation, but claims that the client cannot, then that would be bad faith. See, the problem with the point of view taken by the amicus and by Mr. Studeny is that there are no circumstances under which the attorney could recover if there's no underlying recovery. What I'm suggesting is, and this is what this court did in the Hagelin-Philip Morris case, suppose the failure to recover in the underlying case is because the client tampered with the evidence or attempted to unduly influence a witness or a juror. That would, to me, be a set of circumstances where where an attorney should be allowed to recover. And when I cite the Hagelin versus Philip Morris case, it's with the suggestion that while this court can certainly explicate the law, there may be an insufficient factual record given the status of this case being an appeal on a motion of summary judgment to actually decide how that explication of the law should apply to this instant case. So my request is, just as this court did in Hagelin versus Philip Morris, you provide some guidance to the trial judge below by explicating the law, and then remand the case so that an appropriate factual record can be developed through discovery and trial, and then you would be able to determine whether Liss versus Studeny should be decided for Liss or decided for Studeny.
Thank you, Mr.
Thank
Liss.
you, Your Honor.
Mr. DiViacci.
Good morning, Your Honor. Val DiViacchi for the defendant appellee. Just want to emphasize the key fact in this case, I believe, is the July 15th letter that was brought up by one of the justices. In that letter, it starts out with Attorney Liss telling the client, I am in receipt of your voicemail in which you state you wish to drop the Walmart case and that you wish to meet with me on July 23rd, 1998 to discuss the mechanics of dropping the case rather than for the purposes of preparing responses to discovery. That's what the attorney says his client wanted to do on that date. And his response, if you go to the second page of that letter, is that if he does do that, if he orders the attorney to drop the case, which he's entitled to do under the rules of professional responsibility, the attorney's response was, well, in that case, you are liable to me for the services of a fair billable value of $11,355. And at that point, the client is between a rock and a harder place. He's either, according to what the attorneys tell him, and he has to come up with the money to finance the litigation, or he has to come up with the money to pay over $11,000 in fees to his client. And that's just not true. That one letter and that advice clouds everything that happens for the next 2 years, because the client was not in that place. He had the full authority to dismiss that case and to order his attorney to dismiss that case in its entirety. And
with what consequence of the legal fees expended to date?
Right, that's the question. If that had occurred, if the attorney had done that at that point, what remedy would the attorney have? I submit that at that point, it's not a question of the California or the New York rule that Bar Council brings up. It's a straightforward, simple breach of contract matter. And at that point, we go to the contract, and we see both contracts that Attorney Liss had my clients sign state that the recovery, attorney fee recovery, is limited to any recovery in the case. He used a straightforward boilerplate from this court's own rules. He didn't.
The list of, I don't have it in front of me at the moment, but maybe it's here, the list of mechanisms that would trigger trial, arbitration, mediation, settlement, or otherwise, is it your view that the or otherwise contemplates the client just not pursuing the case?
Correct, Your Honor. If you look at the phrase right after otherwise, it goes on to otherwise.
I'm sorry, I don't have that. I just got the judge. So read it to me.
I'm sorry, page, on both agreements are the same, and it says after otherwise it goes none except from amounts collected. So the fee itself limits any fee recovery to any amounts as a percentage to any amounts collected in the case. And he didn't have to do that. His first agreement, the January agreement, actually had a $5,000 flat rate. So if he would have kept to that agreement, even if there was a complete loss in the case, he would have at least been able to keep the $5,000. And there's plenty of other ways of doing it. I mean, I know what, at any given time, about 100% of my practice is contingent fees, so I know what it means to get burned. And that's why I've amended the boilerplate, and I actually put in my boilerplate the fact that if a client accepts a settlement that involves no monetary value or an unreasonable settlement against my advice, that I'm entitled to my reasonable fees up to
What about and how do you address the fact that if your client just decides not to proceed? Does that come under, settles the case for an unreasonable amount? Let's say the client just says, I want you to move to dismiss tomorrow.
Right, according to the fee agreement I used, the one I've amended, in theory I would have a right of recovery. I mean, as a practical matter, it doesn't make sense because usually my clients don't have any money anyway, so the reason they sign contingent fees is because they're judgment proof. But in theory, if he had amended the boilerplate to add in the flat rate provision like he did the first time, or if he amended it to protect himself in a case where the settlement is zero, he'd have a right of recovery. So in that straightforward breach of contract case, if he had protected himself against the situation, he would have a recovery. But then the other issue is I admit, if there wasn't evidence here of bad faith, and I can give you plenty of examples of that. I mean, I've had a case where,
Well,
sure.
Forget going outside the record. Mr. DiViaccio, is it your position that that we don't have to adopt any, well, let me just back up. From the letter that followed the voicemail where your client, as reported by the attorney, Liss, said, you know, if you drop this lawsuit, you're going to owe me $11,000 plus. Is it clear that your client didn't then, as it were, resuscitate the agreement?
No. I would say it's clear that he didn't resuscitate it. Because if you look at the letters that go back and forth, it's clouded by this fact that now the client has a choice of either paying several $1,000s for experts or paying his attorney $11,000. But all the letters, all the way up to the point of the motion for discharge, indicate that the client is going forward unwillingly and just doesn't have the money. And even when he files the motion for withdrawal, he doesn't file the motion to withdraw based on a termination. He files the motion to withdraw based on irreconcilable differences. So I would say the answer to your question is yes, Your Honor.
Okay.
And,
You used the word burn. He got burned. Is that fair to lawyers that they should get burned for putting work into a case?
no, it's not fair. As I said, I've been in this situation, and I've learned, and I amend my agreements, and hopefully he's learned, and from now on he'll put a paragraph in to protect himself. No, it's not fair, Your Honor. But again, it's a breach of contract.
But isn't that I mean, in any contingent case, and if the contingency doesn't, I mean, just take it all the way to its end, the contingency doesn't materialize, sure, the lawyer's been burned. Lawyers put in a whole lot of work, but that's the nature of the agreement, isn't it?
Right, but it's not if there's bad faith. For example, if you have a case where the client knows from the beginning that economic damages are part of the case and then refuses to produce his income tax forms. I mean, I've had a case where a court ordered a client specifically to produce income tax forms, and for some reason the client just doesn't want to do it. The sanction is dismissal. I think in that case, it's bad faith, and in theory, I think an attorney, regardless, even if he uses a boilerplate agreement, would have a case for his reasonable fees. Where an obvious case is one where there's perjury. An attorney takes a case, discovery starts, it turns out that it's a fabricated case. The client lied to him and is willing to lie to the court to keep the case going. The client files to withdraw, and the attorney's lost considerable amount of time. I think in that case, you'd have, regardless of the boilerplate.
So in essence, you are recognizing a kind of bad faith.
Yes, Your Honor.
You're just saying that you're simply saying that in this case, there wasn't sufficient on a motion for summary judgment to ascertain whether there was bad faith.
I'm saying that it's clear from the facts that there was no bad faith, that the only issue here was that the client wanted to settle the case and the attorney didn't want to settle it. There's no evidence that he perjured himself. There's no evidence that he destroyed evidence. There's no evidence that any type of what would commonly be considered bad faith. It was a purely situation where the client wanted the case to go away, the attorney didn't, and from the very beginning, from the very first day, the attorney was telling the client that he would have to pay him if he dismissed the case, which isn't true. The client has complete authority to dismiss the case. So unless the court has any further questions, that's really all I have.
Thank you, Mr. DiViacci.
Thank you.
We'll take a short break.
All right.